welcome to this week's edition of Wednesday Wisdom. My name is JB Hilliard, and these are short, or meant to be short, video snippets designed to educate you in the areas of estate planning, probate, or other legal concerns you may have. You may just have some general questions, or things may come across my desk that I think would be worthy to share lessons learned with you. So with that said, today's topic is patience is a virtue. How many times have we heard that in our lives? I've heard it lots of times, and my mom used to say, be careful if you pray for patience because God's going to put you in situations that require more patience. So be careful what you pray for. But in essence, what I want to talk about today is patience in the probate process. So whether you are the executor or administrator of an estate, or if you're on the receiving end as a beneficiary or an heir to that estate, you must have patience. The probate process is not a quick process, relatively speaking. And I'm working a matter now where one of the heirs makes it a point to call every couple of weeks or every few weeks to see what's going on. And he doesn't quite understand the process when I try to explain it to him. So it's not necessarily quick. In fact, if it only takes 6 months, in my opinion, that's a very short and fast probate process. But typically here in Georgia, where I'm speaking from, this process can easily take a year, even with the most straightforward estates. In essence, there's the time to actually draft and submit the petition and for the court to turn that around. And in the times that we're experiencing here during this pandemic, there may be a little more of a delay for that part of the process, with the courts being limited in what they're doing or what they're capable of turning around. Then there is a statutory time of notice, what we call the publication notice to any creditors or other claimants to the estate. So there's a publication of 4 weeks for that, so that's a month. And then those creditors have up to 3 months to file a claim against the estate, so that's 3 more months. And so, and then actually statutorily, the executor or the administrator, I'll say the personal representative of the estate, actually has 6 months at least to really ascertain the condition of the estate. So during the process of notifying the creditors and seeing what claims come in, checking the bills, seeing, if anything is owed from the estate, that PR has 6 months to really determine what the assets are, what the debts are, and who the heirs are, the beneficiaries, if they're able to be contacted, all of that. So there's just a process to be done. And if you're the PR, or even if you're one of the beneficiaries or the heirs, you want that PR, that personal representative, to be thorough in what they're doing to make sure they are taking the time to take care, marshal in the assets, or make sure that if there are assets still owed by the person that passed away, that they're kept intact, that all the taxes have been taken care of, any liens, anything like that, that all that has been taken care of before you as an heir or beneficiary receives anything. That PR has to take care of those things and keep track of what's coming in and what's going out and all of that kind of stuff. So the process takes time. And like I said, if it's a 6-month probate, that you're doing pretty good, in my opinion. So just be aware of that. Be aware of your local jurisdictional laws or statutes, whatever those particular requirements may be. As I mentioned, here for Georgia, yours may differ, but just be aware that this is a process and you must be patient, because calling the attorney that's working with you, or calling the actual PR that's handling the affairs of the estate, continuing to call or contact them does not speed up the process, unfortunately. So patience is a virtue. As always, I thank you for watching, and we will see you next time. Be Be safe out there.